All right, everybody, good morning. We are going to talk about selling condominiums in 2025 today. And my name is Sam Saad, and I am a real estate attorney here in Florida. And because I'm a real estate attorney, we are going to start off with a disclaimer that I'm providing you advice, I'm giving you information, but it's not legal advice that you can rely on for any purpose other than what's stated herein. And if you have any specific questions, you need to establish an attorney-client relationship with me. A little bit about me. I've been an attorney for over 20 years. I specialize in real estate law, really real estate contracts. I serve on the committees that draft the NABOR and FR contracts, the two forms we're to look at today. But our firm is a full service real estate business law firm. We handle estate planning, probate, litigation, and we have offices throughout Southwest Florida. I also own a title company, Paradise Coast Title and Escrow. So we do closings. If I can help you with any of your closings, always appreciate the business. I think we're the best there is, and you can reach out to me as an attorney anytime. That's my cell phone number there. Today, we're to talk about a little bit about where we came from in terms of condominium law. There's been a lot of action in the condominium world. We'll talk about the newest iteration that just came out July 1st, so a month ago. We'll take a brief look at the NABOR forms. Real quick, how many of you use the NABOR forms? Ever or at all? Nobody. Okay, well, I'll just show
I
them
do.
to you. I've got
I
like
do
three.
sometimes.
Okay, Missy.
Sometimes.
I got you, Missy. I'll
Yep.
show them to you and we'll talk about them.
I'm
The
actually
rules
just
apply
starting
to
to use
all of
them.
them. Say again?
I said I'm actually just starting to use them.
Okay. Well, they're good forms. The FAR form is more comprehensive because of the way the contract is put together. We'll talk about all that. But let's dive right into what's going on. First of all, the market could be better. Condos are having a problem. These are condos and townhomes in the Cape Coral, Fort Myers market area. And as you can see, the listings are up, even though sales are down. So the market is slowly healing. That's good. I think that the laws we're going to talk about today are a step in the right direction towards fixing the condo market, which is kind of really moribund right now. First of all, where did we come from? So on June 24th, 2021, the Champlain Towers collapsed in Surfside. That let everybody know that we have some major problems with our condominium buildings, especially the older buildings in Florida. By October of that year, the Florida Bar had a committee together that produced a report. It was several hundred pages that basically said we have some major problems and we need some legislation. So there's been 4 legislative acts that have come through, and we're going to touch on briefly on the first 3, which you're probably familiar with if you've sold a condominium in the last 4 years, and then we'll talk about 913. So the first one is Senate Bill 4D that was done in a special session right after the report came out. In from the bar, and basically new requirements for inspection, structural integrity, financial reserves for condos and co-ops. And they basically knew there were structural deficiencies. They wanted associations to get those fixed. So they forced a lot of things like structural integrity reserve studies, milestone inspection reports onto associations. It was done rather quickly, but somewhat effectively, in that it caused associations to now have to raise their reserves. Up next, the next year in 2023, Senate Bill 154 was passed. It provided some clarity, clarified that the changes applied to residential, and expanded the list of professionals who were allowed to perform some of the structural integrity reserve work. And essentially what happened after Senate Bill 4D was they realized that Florida doesn't have enough engineers and architects to inspect, several thousand, tens of thousands of condominium buildings. And so they expanded the list. They provided some alternative funding, and they started a searchable database to show who's actually getting their SIRS and MERS reports done. Then HB House Bill 1021 came down in 2024, and it increased accountability for CAMs. It gave DBPR more teeth in their regulatory authority, proved transparency, required websites that have to be up by the end of this year for larger associations, and it created criminal penalties for non-compliance. That's a big deal. Okay, so where are we at today? Well, House Bill 913 came into effect, about 35 days ago, 37 days ago, and it made some other changes to the condominium legislation, particularly with regard to structural integrity, reserve studies, and milestone inspection reports. Those deadlines got moved to the end of this year from last year. That's a big help. They increased the items that were required to be on the structural integrity reserve study to $25,000 from $10,000. That gave some condo relief to some of the condominiums that were having trouble. And then they clarified habitable stories. So if you've got 2 stories over parking, that's not going to be covered by this act anymore. And then they had a bunch of conflict of interest rules for architects and contractors who are basically self-dealing, going in saying your building's terrible and then coming in and doing huge engineering studies and spending hundreds of thousands of dollars on architects and engineering fees that may or may not have been necessary. So they cleaned up some of that. They made community association managers and firms have much stronger conflict of interest disclosures. Who the CAM is now has to be posted on the association website and on DBPR's website. So DBPR, when you're a CAM, you will now list who you manage, which is going to be really helpful in verifying licenses. And then some governance transparency for condominiums. They allow for video conferencing. They allow recordings, which have to be kept in our official records. That's going to be huge. They allow electronic balloting, and associations have to maintain detailed financial media inspection records online. Online. That's going to be important for you in that when you need to get your condominium documents and all of your financials, like under the FAR bar, you're going to see you need 12 months of minutes and agendas to show special assessments. That's going to be huge for you guys as realtors. Budget reserves. If the budget is going to exceed 115% of last year's budget, then they got to produce alternative proposals that don't do that. That may require lowering maintenance things and other items that you might want to do to cover things you have to do. Insurance, the insurance issue is huge for condominiums because what they were doing was they were raising their deductibles from 5% to 10% so they could afford the premiums, and basically making the condominiums unwarrantable. They couldn't get financing. So now they're trying to fix that problem. And there were a number of changes in the rules for that. DBPR reporting. Now associations and the local agencies, that's your cities and counties, have to report to DBPR, who are creating this huge database of all this information. Just a lot going on legislatively. Does anybody have any questions about the legislative changes? It's a lot of changes going on, and they're going to be reflected in the form, so I will be answering any questions as well. Now, a couple of you mentioned the NABOR forms, so we're going to take a quick look at them. One of the changes in 913 that's really important that you need to know is your condominium governance documents timeline is extended from 3 days to 7 days. That's 7 business days, excluding weekends and legal holidays. So you're going to see that in the FAR bar as well. The condominium documents have to be delivered 7 days prior to closing, or the buyer has 7 days from receipt of the documents to review and terminate. That's a huge get out of jail free card for your buyers. So we'll have to deal with that. This is the NABOR standard resale disclosure. Nothing changed in this from previous forms. It's pretty basic. It's just a copy and paste out of the statute. The one thing that NABOR does that FAR does not is it makes receiving a copy of the governance form the governance form you see here, a condominium document that they can terminate within 7 days if they don't receive. So if you do get NABOR forms, make sure you give the governance form as well. Similar to what you're going to see in FAR, a little bit less intense. NABOR has 6 questions that have to be answered related to milestone inspection reports, structural integrity reserve studies, and the turnover inspection report. The association is or is not required to have the inspection report? If they are, have they done it? And that's for all 3 reports that are required. Notice the turnover inspection reports are only for condominiums that were created after July 1 of 2023. So your older condominiums are not going to have turnover reports. Now, I'll talk about this further in the FAR as well, but there is a conflict in the statute. The statute had an error of and versus or, and so we are required to give 2 conflicting disclosures in the association disclosure documents in the condo riders. The first disclosure, this A up here, says that the buyer has received the association documents, including the reports, and that they don't have a right to terminate the contract. B says that they have not received the association reports and they do have a right to terminate the contract within 7 days of receipt. So what you need to do, if you are required to produce the reports, you need to check either box A or box B, depending on when they were received by the buyer. And this is going to be the same thing in FAR, which we're going to go over in a second. I just want you to see how it's laid out. You check box A if they got the reports, box B if they did not, and they get 7 days. All right, any questions about NABOR before I get into FAR, which we're going to go into in detail? Okay. So let's talk about FAR. FAR has a new condominium rider. I'm going to zoom in and go over the parts of it in detail, but I want you to at least see it in whole, how it's laid out. This is page 2. You can see how it's laid out. Check boxes, lots of blanks to fill in. It's 5 pages. Here's pages 3 and 4. Again, I want you to see it so you get an idea when I zoom in on what we're looking at. This is the box A and box B. You have to pick one. Right to documents, additional documents, common elements and parking. Here's page 4. Again, this is where you select whether your inspection report has been completed and whether it's required. And then page 5, same thing, just 2 more disclosures. Okay. So that's what it looks like in total. That's 5 pages that you'll add to your contract. Let's dig into it. First off, right away at the top, you now identify your association and management company. You fill in your contact person and their contact information, the association website. The seller should be putting this into MLS at the beginning of the process so the buyer can sign it. See here where the website information can be added. Let's not skip that now. The websites are going to be mandatory. Up next is the association approval. Pretty much all condos have an association approval process, especially the larger ones. You check your box for is or is not required. If the approval is required, then you pick the number of days for application. I'm sorry, not application, approval as to how many days before closing. Now this says 5 days prior to closing in this blank. Here, we're talking about this blank right here. I would lower that to 1 day if I were you, because a lot of times the associations look at the closing date and then they don't get it to us until the closing date. So I would give yourself 1 day prior to closing. And then here, this blank is for the number of days the buyer has to make application from when the seller has initiated the approval process by giving the application to the buyer. 5 days, I think, is fine here. NABOR gives 10, but 5 is fine. The next section, section 2, is the right of first refusal. Pretty simple. Does the association itself or do the members of the association have a right of first refusal? Your seller needs to find out from the association what the answers to these questions are, and then they need to be put in the blanks. Most associations have a right of first refusal. Most members do not. And then, how many days after the effective date to get the information from the seller to the buyer. Up next, you disclose in the fees and assessments. I want you to note this word right here. The seller represents that the current association assessments are. And notice that there's only one blank now where there used to be 4. And there's only a blank for rec fees here. That's because you now need a condominium rider for each association. It's very important. If you've got a condominium that's in a condominium that's in an HOA, you need 2 rider A condominiums and 1 rider B for the HOA. So don't forget that and try and put everything on one form. That's a little difficult since form simplicity does not let you duplicate forms. But your other forms programs like .loop, I believe, do. So that's going to be super important. So you represent what the amount is, and you pick the frequency of when it's due. On this coast, not a lot of rec fees, but if you've got a rec fee, you'd fill it in here. And then some language here about all regular assessments shall be made current. And reserve accounts are not prorated, which means if the association's got a reserve in the seller's name, that transfers to the buyer. You don't see that a lot, but sometimes it happens. Up next are fines. Association fines. The seller will close and remedy all open violations at or before closing. So that just clarifies that. Pretty obvious and simple there. Okay, special assessments. So you have to read this very carefully and choose the liability. This subparagraph on special assessments was basically reworked to address a bunch of challenges, including pending assessments. So if there are pending assessments that are things that have been discussed at the board meeting in the previous 12 months prior to the effective date, then you need to disclose special assessments. And if you don't, you run into a problem. You're in breach of contract. So you need to determine if the association has leveled any assessments, then the buyer or seller shall pay the assessments in full at closing. So you need to know that. You need to negotiate that. If an assessment is levied after the effective date, but prior to the closing date, who's going to pay it, buyer or seller? And then if the assessments may be paid in installments and the buyer will allow, the association will allow the buyer to assume the assessments, who pays them, buyer or seller? So you got to negotiate all that. And the goal here is for maximum flexibility in your negotiations over special assessments. So you need to be very careful and have a detailed conversation between you and the other realtor as to who is going to cover these assessments. Questions about special assessments. This is a lot, and you need to know it. Okay. Up next, you need to disclose litigation. The seller represents, again, that means the seller is representing and warranting that they are not aware of any pending litigation except, and then you list the cases here. So if the association has put litigation issues in the minutes or agendas of the previous 12 months, I would argue that the seller knows or has constructive knowledge of the litigation and needs to disclose it, or they run the risk of the buyer being able to terminate the contract. So be very careful about saying, "Oh, I don't know of any lawsuits against the association." And as a realtor, this puts a lot of onus on you to go into the minutes and the agendas for the previous 12 months and see what's going on. Then you have your non-developer disclosures. So this is different from NABOR. FAR follows the statute more accurately. You have two disclosures that are non-developer disclosures. The first one is that the buyer has received the declaration, the articles, the bylaws, the financials, the budget, the FAQs, more than 7 days before closing, and the buyer does not have a right to terminate the contract. The second choice is the agreement is voidable by the buyer because they have not received the association documents 7 days prior to signing the contract. So now the buyer has 7 days to void the contract. So NABOR skips box A and just gives everybody 7 days to terminate. FAR, if you've actually delivered the association documents 7 days prior to signing the contract, you can check box A, and then the buyer can't get out of the contract for condo doc delivery. That's a big deal. Make sure you check the appropriate box. There is case law that says if you don't do this correctly, the buyer can terminate and get their deposit back. So we don't want to mess this up. Okay. Questions about that? You understand the non-developer disclosures? Okay. So in addition to developer disclosures, the seller shall, at seller's expense, provide buyer with current copies of the condominium documents specified above, as well as the governance form. So the seller is obligated to provide the condominium documents. The seller shall, at seller's expense, also provide the buyer with a copy of the following. So if the buyer wants to, they can select all these documents, and then the seller's got to provide it. And again, this agreement may be terminated by the buyer if they didn't get them within 7 days of the contract. So you have to have more conversation with your seller. Where are the minutes? Where are the agendas? I need all these documents. What litigation are you aware of? And then you have to talk to the buyer and say, buyer, what do you want to know? And of course, your smart buyer wants to know everything. So we run into a few little loopholes for the buyer in this addendum. Next
Sam,
up,
I have
you
a
just question,
I have a
Eric.
question on that. If you can go back to that previous slide. Will that mean that moving forward in the future, when all of this information is on the association websites, that this information, their minutes, the agendas, all of that will be readily available to people?
To the seller. It'll be readily available to the seller, probably behind some type of password protected website.
Okay.
So you,
Thank you.
as the buyer's agent, would go to the listing agent, say, listing agent, I need these documents. The listing agent goes to the seller and says, seller, get onto your portal and get me all these documents. And then you transmit them to the buyer and you start the 7 days. That's kind of how this is envisioned to work. Up next, common elements. You disclose parking spaces, garages, or other common elements. Note here that you don't, if you've got a condo with 2 parking spaces, do not put the number 2 in this box. You would put 2A, that's terrible handwriting, and 2B if they've got 2 parking spaces, for example. You would not put 2 parking spaces. You need to tell your buyer where their parking spaces are located. Up next, we have inspections and repairs. The buyer, the rights and obligations under set 11 and 12 of the contract do not extend to common elements. So if you've got the 3rd floor condo in a 3-story building and the roof is leaking and it's causing damage in the condominium, the seller is not obligated to fix the roof. The association is obligated to fix the roof. The seller just has to fix the paint and the drywall on the inside of the unit. And that they may not even have to fix the drywall depending on the association documents. Okay, up next, the new inspection reports. So FAR broke it out different than NABOR. FAR has 3 questions that have to be answered for each of the 3 reports. So 9 questions, 9 check boxes, I should say. First up, milestone inspections. Is the association is required and, see this and, I want to make sure you see this, and has completed a milestone inspection report described in 553.899. Or the association is not required to have completed an inspection report, or is required but has not completed the report, completed the inspection. So see your choices. They did it, they don't have to do it, or they have to do it but haven't done it. And I threw in, when I share these slides with you guys, I'm going to email you my slide deck. I did throw the statute in here, but I'm not going to spend any time going over the statutory language. Just know that statutory language defines these milestone inspection reports. Up next, the same thing with the turnover. The association is required and has completed the turnover, is not required to have completed, or is required to have completed but has not completed. By the way, the reason choices 2 and 3 are in bold and choice 1 is not is because choices 2 and 3 are copy and paste from the statutory disclosure. Choice 1 is the better choice, but it's not in the statute. So for all 3 of these, if you can pick one, that's the best, and you give the report and you're good to go. Okay, and I did put the turnover inspection statute in here so you can see what it was. It's basically a structural integrity reserve study, but it contains more than that. Again, the last choice you have is the structural integrity reserve study disclosure. The association is required to complete and has done so, or they are not required, or they are required but has not done so. Now, it's very interesting from a lawyer perspective, maybe not so much for a realtor perspective, but the statute also has an error. It says that the structural integrity reserve study is defined in section 26 of 103. It's actually what in 28. So I put section 28 down here below so you can see what it is. But the statute references the wrong statute. So the legislature still has work to do, and I would expect even more changes to come from all of this. But for now, at least you see what it is. Okay. So we talked about this under NABOR. Let's talk about under FAR. Again, if you have provided the structural integrity reserve study, the milestone inspection report, and the turnover report more than 7 days before the contract is signed, no right to terminate for the buyer. If you have not provided the milestone inspection report, the structural integrity reserve study, and the turnover report within 7 days, then the buyer gets 7 days to terminate. Where's the other 7 in here? It's in here somewhere. So just be aware, You want to get these reports, all of the reports, all of the documents to the buyer 7 days before they sign the contract. If you have a listing, you need to get the documents into the MLS as quickly as possible. Now, MLS has a document limitation and a size limitation. So another skill that you're going to have to learn as a realtor is how to manipulate PDFs. If you've got Adobe Acrobat or a similar program, you can combine all this stuff into one PDF, save it as a reduced size file, and you should be able to get it into MLS. Everybody understand that? Save it, combine them, reduce them, and you can get it into MLS. And actually, what we do in our office is, if you ask me, I can get you all of the recorded documents for any condominium. So just send me an email and I'll get you the recorded docs. And then if you need help, I'll combine them for you into one document. Okay, last slide is they just removed all the explanations from the multi-parcel building, and they basically just put the statutory disclosure in here, which is all of this. And it doesn't really say any much, except that if you are selling in a multi-parcel building, be aware that the commercial portions, they pay a share of the expenses, but it may not be an equal share. That's pretty much the sum of it. With that, let's talk. What questions do you have for me?
So the disclosures, I'm thinking of a scenario with the 7 days. If we put it up on the MLS,
Yeah,
does that it really constitute them receiving it? They're going to
not
sign
at all.
something and check that box and say they
Nope.
received it, right?
No, you would not check. So the seller wouldn't check either of these boxes, A or B. Actually, 2 or 3 in this, one or two in this report, because the seller doesn't know when the buyer received the documents. The seller needs to check these boxes here, here, and here. If I can go back to so I can zoom in on this, I can show it to you better. The seller, the buyer would check these boxes for the report, for the information that they want. And the buyer would check the boxes for whether they received the association documentation. But the seller would put in any anticipated or pending litigation. The seller will check if the parties will negotiate special assessments, and the seller will fill in what the dues are. So there's going to be some haggling, there's going to be some back and forth, and there's going to be some information. The seller will know if there's a right of first refusal, and the seller and buyer the seller will know if there's required association approval, which there almost always is. So just so I can show you the forms better. So the seller's going to fill all this information in, and then the buyer's going to fill in the other stuff. I would plan, if you buy or sell a condominium, to pick up the phone, which I say that a little bit jokingly, because realtors are like lawyers. We don't like to pick up the phone. We like to send an email. But having a conversation with the other agent about the condominium and the structure and the plan for getting it closed is going to be even more important going forward now.
And that kind of along the same lines, those boxes that they can check off, asking for all that, really importantly, the minutes of the board meetings, if there is litigation that they don't know about, or maybe their next door neighbor, said something, or, there's a hint or a rumor going around that there's going to be future litigation, but it's not in the minutes, that kind of protects you. Does that go along the same lines if you get ahead of it a little bit and put all of that on the MLS?
I mean, the more you can disclose, the better you are protecting yourself and your brokerage. Your seller's going to have something to say about that. But again, it's better to disclose than have a fight later and waste everybody's time and have the buyer sue or get out of the contract.
Yeah, gives you a little bit of a hedge as the realtor.
Yes, it does.
Certainly worth the time doing.
Yeah. So, and the part of the deal is it used to be impossible to get association information out of the association. Now they're required to put it on a website, so your seller should be able to get it fairly easily. At the
Yeah,
end, I
definitely.
mean, it's not required to be on a website till the end of the year, but many associations are already doing this.
Yeah, all I've seen that have done it, and yeah, it does make it a lot easier. That's for
Right.
sure.
It makes it much easier.
I have a question. I see there's a few blank spots down there for buyers to request additional, like 3 other options. What would, we represent a lot of buyers buying condos. What would you recommend we request above and beyond what's already on that contract?
You mean these 3 blanks here?
Yes.
These?
Yes.
I don't know what else you would request. Minutes and agendas for the board and the members, the insurance. Get the reports are done elsewhere. I don't know what else you'd request, honestly.
Yeah, when I see that, I think I'm missing
Those
something.
are typically what I request. The minutes of the board, the agenda of the board, the minutes of the member meeting, the agenda for the member meeting, the insurance information.
What else is there?
I mean, you might request like a loss report for the insurance. I've seen that done. I don't know that's important because the association is going to have the insurance declaration is going to have the deductible information on it, and that's what the lender cares about. They don't really care about the loss report.
What about like Chinese drywall remediation?
You know, you could if there was a history of it, but they got rid of all that drywall. I mean, that drywall was a 2006 and 7 phenomenon.
Right. I know we had it in our condo.
What?
We had it in our condo, and it still comes up every time we sell a unit in our community.
Oh, really? That's interesting. Yeah, that's frustrating because that was around for the Chinese drywall phenomenon. That was a pain in the butt.
Yeah. But we wouldn't need that though.
No, you wouldn't necessarily need it. No.
Okay.
Other questions?
I have a question, Sam. The beginning slide talked about house bills, and there was one regarding reserves. I think it was HB 913. Those reserves have to do with buildings that are 3 stories and above, correct?
All of the statutes that I referenced apply to 3 habitable residential stories and above. That's right.
Okay. And then one more question. The receipt of condo docs, did that change at all, or is that still the same?
So they added the milestone inspection reports, the structural integrity reserve study, and the turnover reports if applicable to the receipt.
Okay.
So you have more than just the original 9 or 10 documents. You have 3 more.
All right. Thank you.
Other questions? Anybody? Come on, free legal advice. Any other questions about other stuff related to condominiums besides these forms?
I actually have a question. I'm a transaction coordinator, and I've been recently, I picked up a few clients that are actually, they work a lot in the Miami area, Broward County, Miami. I know you said that there was a difference in these forms, the verbiage in these forms between NABOR and FR. What about Miami?
Nope, you would follow the FAR bar form in Miami just the same as if it was anywhere else.
Okay, thank
Nope.
you.
The only real difference in Miami as far as the contracts is concerned is the doc stamps, the 60 cents versus 70 cents. Other questions? Anybody? Anything?
That was a lot to cover. Thank you.
Yeah, so there's been a lot of
It was.
changes. If you guys have any thoughts or concerns as you're going through your practice, you can always just call or text or email me. I'm happy to work with you and help you figure it out. I don't charge for it. Just rather get the deal done.
Do you have a title office in Cape Coral?
We do. Yep. Paradise Coast Title has an office on Lafayette.
Lafayette? Okay, I have seen that.
Yep.
All right, cool. Thank you, Sam.
Thank you, guys. I'll talk to you all soon.
Thank you.
Thank you.
Bye.
Thank you.